So people with disabilities are thought of in many ways as inherently vulnerable, but it is that inequality and discrimination that people experience through ableism that leaves people with disabilities vulnerable. And so in situations of risk and emergency, the impact of ableism means that they've been excluded from the broader development of law, policy and practice. And so common action areas such as mitigation, prevention, participation and planning, emergency response, recovery, reparation and redress don't include the needs and specific access issues for people with disability. So this is what Article 11 tries to address. And it does it in a way that tries to address the fragmentation of international law. So if we look to the legal frameworks where we find the protection during risks and emergencies, this is what the work that the committee is trying to do. Look at the fragmentation within that legal framework and deal with the way in which the rights of people with disabilities through international humanitarian law, environment law, refugee law, climate change law and public health law. So these areas will include instruments like, you can think of them as in terms of the instruments such as the anti-mine, anti-personnel mine ban convention, the programmatic work such as the Sendai framework for disaster risk reduction, and the 2030 agenda and the sustainable development goals. So what it's trying to do is look at the way human rights can inform those instruments. So Article 11 requires all parties to take all necessary measures in the protection and safety of people with disability in situations of risk and humanitarian emergency. This is the standard of obligation met by states parties. My apologies. So the question is, how is this standard met in other areas of international legal frameworks? So how do general obligations and implementation measures and individual rights get dealt with across other areas of international law? So what the general comment is looking at is how CRPD informs those areas of international law that can enliven the protection of people with disabilities. So if we read the obligations of international law through a transversal reading of human rights protection in terms of situations of risk across the domains, the explicit inclusion of Article 11 establishes a co-applicability and complementarity of the CRPD with other fields of international law. So what it's asking is that in all those areas, addressing disasters, risks and emergencies, from mitigation right through to recovery and repatriation, that the principles and standards of international human rights law are applied to protect the rights of people with disabilities. The general comment is in its development stage, and we're hoping to have some exposure drafts available for consultation early in the new year. And so I really look forward to our conversation this afternoon. Thank you.
Great. Thank you very much, Rosemary, and speedy recovery. Wishes for a speedy recovery for you. And now we come back to the room. Rowena, are you ready?
Okay.
Share responsibility. Go forward.
Okay. Thank you, and thanks for the invitation to join this panel. Like Marco, it's fantastic to see this sort of interest in legal topics. So what I'm going to talk about today is a legal principle of shared responsibility, and it is quite an important principle. It's a principle that you will find across all disaster management frameworks, but it's a principle that no one really knows what it means. And so our research initially sort of went back to see, where did this principle come from? Where did it happen? And in Australia, where we sort of traced it back, is there was this shift in 2004 in the policy dialogue where government realised that they could no longer be primarily responsible for disaster risk. And as a result of that, this principle of shared responsibility was introduced. And that's the idea that we distribute responsibility not just to government but to other actors, which on the face of it makes a lot of sense. So then what we see is, after the bushfire inquiry in Australia in 2011, is that in Australia all of our policies started referencing this concept of shared responsibility, but not the legislation. So not the legally binding instruments, but the policy instruments recommend and see this concept of shared responsibility. So as I've mentioned, shared responsibility makes sense. When I say to you in this room that it's not just government that responds to a disaster, everybody thinks, yes, that makes sense. But the problem is unless we articulate what every other actor is going to be doing and it is how they are responsible in these frameworks, shared responsibility actually just allows responsibility to be shifted to no one. And that means that many people can be left behind in the event of disasters. And to be perfectly frank, that's how most legal frameworks are existing at the moment. There is responsibility and accountability of no one. So there is no definition. But when we begin to think about what shared responsibility is, we think about it, and the way I first started to explore it was through looking down at vertical lines of responsibility. So this is moving through lines of government, you know, from federal to state to local or national to subnational, that vertical responsibility. Even those lines of responsibility are often not clearly articulated within the policies or arrangements. But then beyond that, Sendai really makes us pay attention to the fact that it's also horizontal responsibility. So that's responsibility for non-state actors. And I'll give you some, because we're in a law panel, I'll give you some article references. So Article 19 of the Sendai framework, 19A, is really sort of still saying that the primary responsibility for disaster risk is government. So primary responsibility is government. Article 19B is saying that vertical responsibility. So it's saying we need to share it across the different levels of government and clearly articulate. And then Article 19E is saying we then need to share it across non-state actors as well. And what Article 35 does is it tells us, well, who are these other people that aren't government? And there are 5 or 4 different groups. So there's civil society and many of the groups that we have seen represented here today. And that's in recognising the important contributions of women, children, people with disabilities, older people, Indigenous people and migrants. It's recognising the role of academia and scientists as the second group, the role of the private sector and business as the third group, and the role of the media as the fourth group. So our research on shared responsibility, first of all, started by just trying to figure out what it meant. So taking a suite of disaster laws and policies, because in many countries, if it's like Australia, there are numerous policies, and it's very hard to see how they connect or don't connect or relate to each other or don't relate to each other. So we looked at 12 of these policies and we found that they referenced shared responsibility, but none of the policies defined shared responsibility. None of the policies articulated which actors were responsible in these instances. And what this allows is for no one to be held ultimately responsible. It also meant that the legislation does not reference this principle, so it's not within the legally binding parts of the legislation. We then went and did some interviews with civil society organisations to say to them, hey, have you heard of this concept of shared responsibility? And they said no, even though they hold quite a lot of shared responsibility, being the first and last responders. But when we asked them to think, what does it mean to you? What they told us is it was like being a good housemate, or it was like cutting a cake and sharing the cake. Because these groups are often volunteer groups, their view of shared responsibility was volunteering their time and being a good person to their community when they needed to contribute. And that was really interesting. And in that research, the other part that we began to realise was that within apartment buildings or vertical living, that there was actually people just standing up and starting to take responsibility for management within those building structures, within the body corporate or sort of strata title arrangements as well. So what do we need to do to improve shared responsibility? Well, if we want to have responsibility, accountability and liability, we do need to start with a mapping, effectively setting out a framework of who are the actors and what are the types of actions that need to sit here. That would be a conceptual framework. The much trickier part is then getting governments to actually agree to document and list these policies around a room. And that's very contentious because that is shifting responsibility. It is making people liable. There are more things that I could say, but I will just go on to sort of say as well that we need to also think about really the private sector, and in particular the role of potentially the sort of UN human rights due diligence provisions and the requirements for the private sector to ensure that they are not increasing disaster risk as well. So that can be done through planning laws, but it can also be done through due diligence reforms, and I'm happy to talk a little bit further about that later. Secondly, shared responsibility should of course be framed in a rights-based approach, as we've heard here today, and that makes sense with international developments. And finally, we need to be thinking about prevention. So we need about who has responsibility for prevention activities, both vertically and horizontally, and how does that align? And how is that backed up by legally enforceable standards and mandates?
Great. Rowena. With your research, you are opening a can of gold, I would say, in the sense there's a lot of great stuff that can and will come out and will be of great help. Finau, work of IDRL, the incredible work the IFRC does with communities since ever, the link between law that is up there and communities which are really the reality of our life. Your reflections. Thank you.
Thanks so much, Marco and Malolele. Good morning, everyone. Thank you so much for the opportunity to speak on something or an area that the IFRC has been working on for such a long time. So we call it disaster law, but it's really looking at the frameworks around disaster risk management and the full cycle of disaster risk management, and we've been doing that for about 20 years. So it came after the Indian Ocean tsunami. We were given this important task, and really it's to support governments to strengthen their legal frameworks in a whole raft of areas. We are incredibly excited about the draft articles, and that's because even though we've been doing this work with the IFRC for about 20 years, it's soft law, it's recommendations. So we can spend a lot of time speaking with governments, the law, the policy makers around what needs to go into a law. They should be consulting with communities and, all of these sorts of things. We talk about gender, we talk about marginalised groups. If they decide at the end of all of this consultation, all of this work together, all of this collaboration, that actually no, we're not going to put that into our law. Or the government changes and this is no longer a priority for the new government. Nothing happens. Nothing has changed. Risk is still there. And so this has been our kind of ongoing issue, is these things are not binding. And unfortunately, we have this discussion a lot in terms of international law. There's lots of international treaties that cover various aspects of disaster risk management, but they're sectoral, so they only cover maybe telecommunications, or they only cover shipping. There's nothing that's broad that covers the whole cycle. And then also when you do have those international treaties or conventions, only a number of governments have signed them, not everyone, they're not universal. So the fact that we potentially have the makings of a legally binding treaty that puts an obligation on states to reduce risk. This is a legally binding obligation, is extremely exciting, potentially revolutionary for, I guess, the disaster risk management space. I've gone totally rogue and off topic, but I just really wanted to make that clear in terms of how potentially groundbreaking the draft articles are. And we've got the Philippines doing an incredible job of negotiating what that text looks like. For us in the Red Cross, Red Crescent movement, everything needs to be bridged between our legal frameworks to actually the reality on the ground. And that's where a lot of our national societies have worked really closely with their governments to ensure that. And Vanuatu, we've done work in ensuring that. So our community chiefs in the villages, they play a crucial role in terms of community governance. And so being able to link, Vanuatu Red Cross was able to work with the community leaders to link them to the existing DRM structures when we were working with the government in terms of the Vanuatu DRM law. Fiji Red Cross has just finished, they have a brand new minted DRM law that was passed a couple of weeks ago, where they have embedded into their national laws community consultation, marginal groups consultations, embedding of traditional knowledge. The national societies, but also other civil society organisation groups are also part of their national disaster management councils and groups, planning groups, for example. And so for me, I guess if I had 3 points, I would say everything we've talked about, if you're serious about it, mandate it. You need to put it into your national law and your national policy. That's it. 2, resource it. Don't just put it in the law, but have no money for the consultation. You've got to put some money behind it so that it can actually be done. And 3, you need to provide an empowering, enabling environment for that to be done. So that once you've got the law, there needs to be dissemination. There just needs to be action to put those things into place. I've totally gone rogue. I'm going to hand back the time now. But this is the draft articles. If you're hearing about it for the first time, please go look. It's incredibly exciting. Thank you.
Thank you, Finau. Actually, I was so excited myself too that I forgot to introduce myself. At the beginning, so my name is Marco and I work for the UN Office for Disaster Risk Reduction. A lot of great stuff. John, I'm going to call on you. A lot of the stuff has come up now. Let me just pick up a few points where I would invite you, John, to reflect. And also then colleagues and friends in the room, or soon to be friends, use them to share your questions and reflections. So just going backward, the question of mandating it, as Finau was talking about. 2 reflections here. In 2015, we agreed to reduce disaster risk and losses Where we are now, disaster risk and losses are increasing. So we are going the wrong direction. Second point, one can argue that fundamentally creating disaster risk is still legal. Let's think about it. So if we need to mandate it, what does it mean? How do we design such an obligation? And it has to be an obligation that is commensurate to reality. It cannot be lofty, because otherwise we know that laws that are too lofty go nowhere. So where's the commensuration point? Where is the balance? What type of an obligation it is? And then the question of due diligence was called into question. Science, technology, and innovation are fast progressing. So how that can be embedded in processes to assess due diligence? What due diligence was in this field 2 years ago or now was not 10 years ago. So how do we support lawyers, judges, and others to apply in practice that due diligence? It's not easy. What type of normative frameworks we need to use? We know that to pass a law, it doesn't take 3 days and a half. Actually, it's quite a long process. So to integrate this fast progress of knowledge, what instrument do we need to create? So that, what is the menu of options that we have and there? And here, also at the international level, there were reflection on, hard law, soft law. How do we balance that? And we have a good example between Sendai, which is a soft law instrument that can be updated more frequently, let's say the other pieces of international law. How do we use that commensuration? The mapping is quite an amazing, offers an incredible point of view to analyze law. The question of also Rosemary was framing in terms of the fragmentation, what it means to have a more coherent framework between within national context as well as the international law, and how we make the full use of the power that is behind human rights law to analyze realities. And the question of redress also that you raised, Rosemary, I think was quite an important one. And the fundamental issue that it is inequality that makes people vulnerable. So there is much more work that we need to do on that front, domestically and internationally. And then the fundamental point of going beyond disaster. What does it mean to legislate for prevention? So a few questions there. John, I invite you to make some observations. John is leading a very important work in Christchurch at the university. He hosted us for a very important and interesting conference a few months back. John.
Kia ora koutou. Thank you, Marco. I think you've actually summed everything up, so I'm not sure I can add much. But thanks for the chance to talk. As you said, I'm a professor of disaster law. I work at the Lead Institute for Law, Emergencies and Disasters at the University of Canterbury in New Zealand. And we welcomed Marco and his team to a conference earlier this year. The thing that strikes me about this, as Marco said, I think this is a really positive meeting. Here we have a group of people all discussing law, all discussing disaster law. We had a conference earlier on this year with 100 people all talking about disaster law. That's amazing, because until recently, I don't think people knew what disaster law was. I used to turn up to conferences with engineers and scientists and stand up as the lawyer, and they'd think, what are you doing here? And I think part of the issue, and I hope that the shift, there's a change, is that there was two silos. There was people who understood disaster risk, and there's people who understand law, and there wasn't many who did both. And now, I think we're getting to a change where, hopefully, those of us who know, who work in the law, that we understand the law is not just what it says in a book, it's not just that what that court judgment is, it's how it works in practice, it's how we manage our daily lives. And those of us working in disasters, of course, know that disasters are not natural. We no longer say that. Disasters are social events. So if you have a legal system, which is how you manage your lives, and and a social event like a disaster, law is going to be at the heart of disaster risk reduction. And I think until recently, that hasn't been obvious. But the fact that we see this group here and we see the work of the RFRC, which I think has done a lot to drive this, it means that we're making progress. And I think we can see this broader view of law in the draft articles. I know everybody's getting excited about the draft articles, so I'll join the gang. I'll also get excited. I should say I'm a convert, because originally when the draft articles were brought out, which 2016, sorry, my memory may be going, I wasn't that confident, because the ILC produces a lot of soft law. It produces a lot of principles. Many of them are very good, but they don't go anywhere. They just become principles. But this has changed, and I think partly that is to do with the actions of particularly the Philippines, but also a number of states in this region who have actively pushed for a treaty. So that's incredible. And the thing I would say about the draft articles, and it's raised by the speakers, is much broader than the original conception of disaster law, which was about response. So the fact that we've got that broader idea in this potential treaty is, again, a real shift to understanding that law is going to impact everywhere. So IDRL, the International Disaster Response Law, was the sort of seed. That's where a lot of work was placed, but now we're broadening it into disaster law as a concept, and it's great to see the draft articles reflecting that broader view. Particularly, I think the idea, as it was mentioned already, and I'm sorry I forgot the article, but the creating the duty or the potential duty to reduce risk, which is astonishing if that can be put in the final text. We've also heard the developments of international law and through the Convention on the Rights of People with Disabilities, and because that's part of this fragmentation that we currently have, lots of little bits and bobs of international law that deal with disasters. That having a single source, I think, again, can drive those other instruments and coordinate them. But the thing I would say, and I think Marco hinted about this at the end, and I think Pina did as well, that it's not just about those international frameworks. We have to be careful. I think we get sometimes international lawyers get very excited about the international frameworks, and we forget that they've got to deliver on the ground. And every aspect of the disaster cycle needs legal framing. You won't achieve what you want without some form of legal framing, and it can have soft law and custom, and there can be other ways of doing this, but you're going to have to find ways of framing things. But partly I think it's to shift the narrative. I still find that certainly in my own experience in New Zealand, when we talk about law and its role in disasters, it's seen as an enemy, something that gets in the way. We don't want law, get out of the way, we know what to do. We need to change that mindset, that attitude. Law is there to get us to where we want to go. It should be our friend. It guides the decision maker. It helps them make the resilient community. The planning law is there for a reason. I know it can be annoying to say you can't build there because there's too much risk. But if you do, there's a reason, and we'll pay down the track. We've seen this in New Zealand with a shift towards quite a lot of lower planning regulations for economic reasons, which one may agree with, but it sidesteps the DRR aspects, and that's the thing that having the treaty could make a difference, or just even that normalization, because it accepts the idea that you need to normalize your consideration of disaster risk at all times. Also, the concept of legal preparedness strikes me that this is something we've sort of written a bit about in our work, that we prepare other aspects of our systems. We prepare our supplies, we prepare we train for the day when the hazard comes, but sometimes we don't think about the law. You need the law to work on the day. You don't need a new one, as somebody mentioned. You don't want to spend time thinking about a law in the midst of a disaster. I can't think of a worse time to be creating law than in the midst of a disaster. And in New Zealand, again, using my own experience, we are terrible for this. We do not legally prepare, and we do the same thing again. So we might be learning from that. But this concept of legal preparedness as well as other aspects. So the one, just this was the overall thing, the thing that struck me in this conference is that, that almost every session that I've been at has had a legal component. It's maybe not recognised, but it's there. And I think we need, the fact that we've got this meeting here, the fact we had our big conference earlier in the year, which had criminal lawyers and planning lawyers and human rights lawyers and humanitarian assistance experts all in the same room, all having something to say about what happens in a disaster, shows that we're shifting the dial just a little bit. So I would finish on the comment that, in my view, if we're serious about Sendai, if we're serious about achieving the goals, which, as Marco has said, we're possibly not going in the right direction at the moment, but if we're serious about achieving them, then we need to be serious about disaster law too. Ka kite anō.
Thank you, John. Floor continues to be open. Ask the questions that you always wanted to. The panel is ready. Hola. Oh, wow. Can we extend the session by 3 hours? So let's start from the front row and then we go in circle. Please, madam. I think probably I invite you to keep the questions super short and sharp, so to give our friends the opportunity to reflect on and indicate the person that you would like to respond. And then I will need to save 4 minutes for one question to the 4 panelists.
Hi, I'm Sana Siddiq from Pakistan, working as a social safeguard and resettlement specialist. The session was very informative and giving the insights to us to do the advocacy for the DRR. And it's amazing to learn about the some soft articles and the shared responsibility and the community consultations, which was very necessary. I just want to ask the first one. I have a recommendation for your question to assess the due diligence. There might be a central citizen web that should be opened. The information of the all details should be opened, and there is a committee at the grassroots level. The committee to assess the due diligence is formed from the. There should be maybe some person from the NGO sector, from the human rights defender, lawyers, and the media persons. They can assess in the better way, and the committee may be at the ground level, and data may be compiled at the central level. So, because data sharing is a issue everywhere. My question is from one of the colleagues from the Philippines who designed the soft articles. How you navigate this soft article, and what the challenges you have faced, because we learned from you to face the challenges, and so that we can, if we will have opportunity to design this type of the article, we have a way forward. So I just want to learn about the challenges, and one another thing, how you just collect the international consensus from the international forums. Thank you.
Thank you very much. Maybe since there are a few others, why don't we colleagues, why don't you come to the mic already so we save time? 1, 2, and 3, please. Yes. So, super sharp question.
Okay. This is a very simple question. By the way, I am Rome from University Resilience Center at Bataan Peninsula State University. Though we know that academia is part of the local community, as much as we focus on the disaster risk reduction and management in the local communities, with the government as the implementer to mitigate it, what about the academe? As we all know, hundreds or thousands of students are at risk due to the hazard present. But to date, there's no strong foundation of legal basis in the legal basis for DRRM in the academe, especially locally here in our country. Thank you.
Thank you. I think that this is a question, very important, interesting one, actually. Yes.
Good morning, everyone. I am Marcelo Monquil from Southern Central Mindanao. No, so we are talking about the disaster and the risk. As a person with disability, I am already carrying my disaster. Yes. And based on this legal foundation of the disaster, based on my observation, especially in the Philippines, we have the panel from the Philippines. We have the national law about the disaster, but it is limited in adopting the law in our locality. Why? Some our LGUs, yes, they are adopting this law, but the problem, they are not include what is the right base of the person with disability. First, our province in Sarangani province, almost twice a month, we experience earthquake. So when earthquake is hit our province, so what I have to do is only pray to save me. Why? Because the community, my parents, my neighborhood, they don't know how to respond and to help in terms of person with disability. So based on the UN and CRPD, we hope that the concrete and not only by way of response but to rehabilitation, because based on my experience, the accessibility not only by structure, accessibility for the communication, accessibility for any the barriers of the community, that is most important. So based on my own experience as person with disability. Thank you very much.
Thank you very much. And then I take last question. Yes, please.
Good morning, everyone. I'm Ronilda Ko from the Asian Disaster Preparedness Center. My question centers on the concept of shared responsibility. Has the study actually taken a look at, shared responsibility within the context of centralized and decentralized governments? Meaning, how does these two kind of governments actually shape, the perceptions, the implementation of shared responsibility, especially that we are talking here significantly, in this APM-CDRR, the concept of localization as well and all that. So how does this, how does it change? What are the challenges, of all these legal foundations of shared responsibility and all this, all the like, in terms of really looking at, there are different forms of government globally. So that kind of, question and thinking. Thank you so much.
Thank you very much. So let me address, thank you, Brownen. My colleagues are keeping me on target. So I will address directly the question to you. Rowena, do you want to take this last point on sharp and due diligence?
Quick.
Yes.
On due diligence? Or
Yes, please. The last one on due diligence.
on shared
Responsibility, yes.
Sure, yes. So we've only started by looking at this research in the Australian context, but the principle of shared responsibility, now that you know about it, you're going to see it in every legal framework. So it's not only within disaster laws, where we initially found it was actually within circular economy laws, so to deal with plastic and things like that. So it exists in absolutely every framework, most legal frameworks. And again, that principle is still relevant whether you're talking about a centralised or a decentralised model, but the application of that principle will vary according to the different government structures. I think so.
Thank you. Rosemary, can I call on you? What do you think could be the guidance from the committee and others, to the question number 3?
Thank you very much, and thanks for the question. For me as a human rights lawyer, the best thing about the way the cross-cutting up article 11 works is that it can embed the standards and principles contained throughout the CRPD, and they can operate in terms of law, domestic law, both centralised and otherwise, but also shared responsibility because third-party actors can be captured. So you're looking at things like participation rights, so ensuring that state parties and third-party actors, in terms of the whole spectrum of disaster risk reduction from mitigation right through to redress, are engaging with people with disability to ensure that not only their needs are being met in terms of that, but there is also an understanding of how disability plays into mitigation frameworks or has issues for recovery plans. And so it's about making sure that that whole process is disability informed. The same with non-discrimination. So the standard of non-discrimination, making sure that public health programs don't discriminate in the area of disability. So people with disability are not only informing public health programs, but also public health programs are accessible to people with disability, so as looking at ensuring that resilience is built in across the population groups. So I think the law needs to be able to be understood in a very cross-cutting way, and it shouldn't be seen just in isolated silos. That's why I think Article 11 has the potential to be so powerful in terms of addressing the fragmentation of international law.
Thank you. Thank you very much, Rosemary's important message. Now, academia and local communities, reflections.
I'll probably reflect on a couple. So with regards to the question about the disability...
But the time is the same, eh?
Yes, the time is... I'll be super quick. So I think as I mentioned before, passing the law is great and it's only the first step, but how that then translates down to the community level is a very, very crucial step. And in the Pacific, we have a lot of examples where local government is working with local Red Cross, Red Crescent actors to do the consultations, and they develop much smaller things in the law. So these are village preparedness plans, these are community preparedness plans that sit under a much broader law, and it's these plans because we call them town elders or village elders. They know their communities, they know the risks, they know the vulnerable groups, and they are consulted and put into these plans. So I think the crux is that to get from the law down to the local level is an incredibly important point. And as Rosemary said, there are lots and lots of community groups that can support local government to do this. Again, the same with academia in terms of involvement in disaster risk reduction. So I think what we're seeing now, I mean, just today in this group of people, as John mentioned, there are people here that we've been working in disaster law for 20 years that we would never have been talking to. And I think the scope is broadening, and the interest and probably the relevance as well of disaster risk reduction, embedding resilience into your legal frameworks and the fact that you can actually do that. I think it's reaching a much broader audience. Was the question on what is the role of students in this, or? If
you have 10 seconds to reflect on it, yes, I think the
yes,
question is...
Yes.
But then I want to come, I have one question each, important one, but I have the first one.
Okay, I'll just say the last thing. So students, if you're interested in this area, there is a career in basically in this. Yeah.
Great, thank you. Yara, question number one.
All right, thank you, Marco. So I will note the first question. There was a comment made on due diligence. So that is, I think, very well noted. But focusing on the latter part of that intervention, I think the question was really, what are the challenges that we have navigated in as we have we've been engaging with these draft articles. And I will say that I think that it is the quintessential question, or dilemma rather, in multilateral negotiations. That is, the tension between what is needed and what is acceptable. So in this case, as we have seen in all of the, my fellow panelists' reflections, it's very clear that there is a lacuna, there is a gap in law when it comes to the area of disaster response and also in disaster risk reduction. And the draft articles really do have the potential of filling filling those gaps in. But then we see that on the floor, even though there is broad cross-regional support for the draft articles, we still have noted that there is resistance because, as we see, one of the revolutionary features really of the draft articles is the introduction of international legal obligations, the duty to cooperate, duty to reduce the risk of disasters, and all of these things. And that's really what we're after and what we're hoping for. But then at the same time, those objections from the floor, because when you're talking about international legal obligations, it is much more difficult to agree, for a state to agree, because then you bring the question a bit closer to the issue of state responsibility, which is different, and that question would probably not arise in the context of a soft law or soft instrument. So I think that is probably one of the fundamental challenges that we face, and probably we will continue to face even as we discuss a possible treaty in the future.
Thank you. Now, since you alluded to something, and I will imitate what happened in plenary 3, where the moderator said, this conference is about the surge to 2030. So in 30 seconds each, I will ask the panelists to say, what is the surge to 2030 for you in this area? Rosemary, sorry, not Mary. I was looking at me. Rosemary, surge to 2030 in 30 seconds. What is your take in this area?
In this area, I would really like to see a convention. I think the ILC draft articles provide great potential, but we still need to be able to overlay it with the human rights principles, and that's why I think hopefully with a strong general comment from CRPD that will give a jurisprudence framework that can give a convention not just a disaster risk reduction lens, but also give it a much more thematic human rights lens.
Thank you. Very powerful. Your surge.
It has to be the same, Marco. It has to be a legally binding convention, the protection of persons in the event of disasters. And hopefully it will be concluded somewhere within the region.
Great. Your surge, Rowan.
I have to also agree that that would be the ideal scenario. But for me, I feel like there is a huge disconnect between sort of climate adaptation law and disaster risk reduction, and I feel like there's a huge crossover and they need to be narrowed and brought together. There is conversations occurring in separate forums within the UNFCCC and then within Sendai. I think there's greater brand. And obviously, I think that moving forward, surging, we need to redefine shared responsibility and articulate it.
Great. Thank you. Finau, your surge.
I disagree. Of course I don't. I agree. But yeah, I think for all these reasons, but also draft articles, a treaty that also goes right back and puts communities at the centre and empowers communities as well, I think would be the dream.
Thank you. So then I abuse the privilege of the moderator. I said that my surge is we need to defend the shell in the future convention. No should, shall. That is the obligation to come. So with this, I thank these great panelists. Rosemary, thank you very much for being with us. Again, best wishes to you, and thank you very much for you to be in the room, and allow me also to thank my colleagues for organizing this session. Thank you.